Under Constitution of India, the executive is endowed with certain legislative powers. For instance, the ordinance making power under Article 123 and 213. It also has certain judicial powers under Article 103 and under Article 192. The legislature is also empowered to exercise certain judicial powers under Article 105 and 195. The judiciary also exercises certain legislative and executive powers under Articles 145, 146, 227 and 229. In addition, the executive exercises substantial quasi-judicial powers under several statutory provisions whereby tribunals have been set up. Parliament, the highest legislative body in the country, also exercises quasi-judicial powers in the cases of impeachment of judges under Article 124 Class 1 and Article 217 of the Constitution, and also in respect of contempt of legislators under Article 194 Class 3. So, the concept of rigid separation of powers is not strictly provided in the Indian Constitution, but we cannot say that there is no separation of powers or functions at all. Yes, there is, but it is very broad. The reason for the broad separation of powers is that concentration of powers in any one organ may destroy the fundamental premise of a democratic government to which India is pledged. Justice K. Ramaswamy observed in the case of Kartar Singh versus State of Punjab that it is a basic postulate under Indian Constitution that the legal sovereign power has been distributed between the legislature to make the law, the executive to implement the law, and the judiciary to interpret the law within the limits set by the Constitution. A landmark judgment on the separation of powers was delivered by the Apex Court in the case of I.R. Kuhilo versus State of Tamil Nadu. In this case, the court has emphasized on the importance of separation of powers and the system of checks and balances envisaged in our Constitution. It observed that for preservation of liberty and prevention of tyranny, it is absolutely essential to vest separate powers in three different organs. The court reiterated that separation of powers between legislature, executive and judiciary constitutes one of the basic features of the Constitution. It was further observed that constitutional amendments are subject to limitations, and if question of limitation is to be decided by the Parliament itself, which enacts the impugned amendment and gives that law a complete immunity, it would disturb the checks and balances in the Constitution. The authority to enact the law and decide the legality of limitations cannot vest in one organ. The validity of limitation of the rights in Part 3rd can only be examined by another independent organ, namely the judiciary. Thus, Constitution of India recognizes doctrine of separation of powers, but not in the strict sense of the term. Professor Wade writes that the objection of Montesquieu was against accumulation and monopoly rather than interaction. Montesquieu never used the word separation. Therefore, not impassable barriers and alterable frontiers, but mutual restraint in the exercise of powers by the three organs of the state is the soul of the doctrine of separation of powers.